Good afternoon, Jarella.
Good afternoon. How are you?
I am fine. You got the copy of the shareholders agreement?
Yes, ma'am, I did.
Okay, did you read it?
I skimmed over it. Yes, ma'am.
Okay, wonderful. I'm glad you skimmed. At least you'll have an idea. Okay, let's wait on the others.
Yes, ma'am.
Yeah, they normally on time. Okay, so let's wait on them. They should be coming in shortly.
Ms. Archer is going to ask you something, but I remember this is recorded, so I'll email you.
Okay, all right. Not a problem.
Okay.
Sherelle, I think we should start because it'll be recorded anyhow.
Okay, not a problem.
Just in case they're running really late. All right, so last class we looked at shares and dividends. And so what I want to tie in with the next chapter, which is company management, is the shareholders agreement.
Okay.
Because you find that when you have issues with the directors and duties that they carry out, sometimes you have to refer to the shareholders agreement.
Okay, is the shareholders agreement and the articles of association used interchangeably? Is it the same thing? No, not quite,
No,
huh? Oh,
no.
okay.
Totally different.
Okay.
Okay, so let me explain it to you. When you incorporate a company, that involves you preparing and filing your memo and arts.
Mm-hmm.
The shareholders agreement is a separate document.
Okay.
And that's where the shareholders set out all of the matters that are not clarified in the articles.
Okay.
So that's that whenever there is a dispute.
Mm-hmm. They go to the agreement.
Right.
It's just that when I looked over the document, they had, I got confused because I think I saw shareholders agreement and then they had / articles.
Where you saw that? Let me see.
Let me try to open it up again. Let's see.
I'm trying to see if I have it circled in mind to explain. I don't.
Shareholders agreement.
I see shareholders / directors. I see that point.
Okay, maybe I was having a moment.
No. Okay, let me start and then it may just jump out at you.
Okay.
Just go through it and it may jump out at you. That may be the easiest way to do it.
Alrighty.
Okay, so what exactly is a shareholders agreement? It's a document, an agreement. So agreement is similar to a contract, but really in it, they're different things. Because you're looking at matters that may arise that you need to discuss how you're going to address it. So what it does is it regulates the relationship between the shareholders and also the management of the company. So let's just say you have 2 directors and they now want to add on 3 directors. So you go to your memo and arts, and your memo and arts says the maximum number of directors can be 4.
Okay.
And they want to add on 3 more to make it 5.
Mm-hmm.
So then you need to go to your shareholders agreement. What did the shareholders say? So let's just say in the shareholders agreement, they said that they will not have more than 7 on the board.
Okay. Mm-hmm.
So that means that according to the shareholders, you can go ahead and increase it.
Oh, okay. So even if the documents there's a discrepancy, the shareholder agreements can override the
No, it's not going to override. It won't override. It will guide you.
Okay.
Okay. So the shareholders agreement said they'll take up to 7, but the article say 5 or say 4.
Okay.
5. So because the shareholders agreement allow you to go up to 7, you can amend the articles.
Okay. Got it.
And increase it to 5.
Okay.
That's where all these amendments come in. That's why it's good to have a shareholders agreement. Okay. So it talks about the relationship between the shareholders if there is a dispute. It talks about the management of the company. So anything that the board has a discrepancy on and the articles doesn't explain it or doesn't give direction, you can go to the shareholders agreement. And they talk about the ownership of the shares. Like what happened, they could actually agree that in the event one of them dies, what they will do with the shares. Because don't forget now, this is a group of people who sat around the table and made a decision. Come together to own this company And so they can decide how they want things to operate. And they could also provide in that protection for the shareholders. So it says here, it makes it usual to combine the use of the shareholders agreement with the articles. So that may be why you saw that slash. They're
Okay,
written together. Yes. That's the usual nature.
okay.
So the shareholders agreement often used as a safeguard and to give protection to shareholders because they can provide for what happens if things go wrong. So imagine you have two shareholders, 50%, and they come to a disagreement. How you going to settle that if you didn't have a shareholders agreement? They will stay bickering between each other for years. And what happens? The company dies. So the shareholder agreement is really, really essential for persons when they wish to enter into or go into buying shares in a company. And you see this more in private companies. The agreement could include the financing of the company. They could put in the shareholders agreement that we will do private equity, we will do venture capital, but they could decide that certain risky areas they will not get into. They will not take monies from those risky areas. They could also talk about dividends, how often they will pay dividends, the procedure to be followed for the transfer of shares, the deadlock situation, and the valuation of the shares. All that could be in the shareholders agreement. So when there is no shareholders agreement, like I said, you open yourself up for disputes and disagreements. And so shareholders agreement contain provisions that preempt disagreements and set out appropriate ways for disputes to be addressed. So this is how you should protect yourself. So it says here that even if the directors have shares in the company, they are likely to be motivated to act in the best interests of shareholders as a whole, rather than representing the interests of the largest single shareholder. Because that you see that when we start talking about directors, that they have to do it as a whole. So generally in small private companies, there are usually few shareholders, and the shareholders are often the directors in the company. That's for small companies. And other than that, when you have a large company, of course, it's public. So with public companies, you wouldn't see a shareholders agreement. You have any questions so far?
No, ma'am. So far, so good.
Okay, all right. So a shareholders agreement can also protect minority shareholders. And that's a good thing, because normally the minority shareholders are the ones who normally get faced with difficulties when there is a dispute. So shareholders agreement, like the note says, are designed to contain provisions intending to protect the minority shareholders. And the minority are those that own less than 50%. You'll find sometimes in some companies, people could have an interest of 2%, 3%, 4%. Those are the minority shareholders. And so, in the eyes of the majority shareholders, they don't pay any interest to them. So a minority shareholder in a private company is the vulnerable one. And this because they tend to be much fewer shareholders in a private company. It's more likely the control of the company will be held by one or two persons. and there's generally no market for the shares of a private company. And a shareholder who is unhappy at the way a company is being run does not have the option of selling those shares. The concentration of control in one or two shareholders can lead to abuse of power, even where no single shareholder holds a majority. And you'll find that a lot in small private companies, where the person who owns the majority of the shares abuses their power by giving all the instructions and saying what should be done. And then it gives you an example. But the shareholders agreement also protects the majority shareholders. The majority shareholder may wish to curb the powers of the directors if he does not have a majority representation at board level. So that's another advantage of the shareholders agreement, because in some instances in the private company, the shareholders would become directors on the board. But let's just say they decide that they don't want to be involved in all of that work and have all of that responsibility. So within the shareholders agreement, they're going to provide provisions that's going to protect their interests. So the majority shareholder may not want to include any minority protection provisions, but may want to be able to ensure that if a buyer for the company comes along, he can sell all the shares in the company, forcing the other shareholders to sell their shares. And this would stop him being held to ransom by a minority shareholder. He may also wish to consider appropriate non-competition and confidentiality covenants and provisions requiring financial input from other shareholders. So I know you would have seen or heard or read whenever someone is leaving, there is that non-competition clause.
Yeah.
So that non-competition clause for certain senior positions can also be in the shareholders agreement. And then it moves from the shareholders agreement then down to those respective contracts. If a shareholders agreement does not exist, any dispute between the shareholders or the directors will have to be settled by what is within the Articles of Association. The Articles of Association are one of the two constitutional documents, and the articles set out the rules as to how a company is run. The shareholders agreement gives a contractual remedy if the terms are broken, whereas the articles may prevent the event happening in the first place. So some of the problems with having no shareholders agreement and must rely on the standard Articles of Association are as follows. There is nothing to prevent a director from being removed by 50% of the shareholders by an ordinary resolution. In law, a company cannot promise to do or not to do certain things. A shareholders agreement could be worded to bind the company. All major executive decisions by the directors are made by a majority, including decisions to change the nature of the business. Therefore, even though they may be a majority shareholder, as a single director, they could be outvoted. Even if the articles are made to protect shareholders, they can be amended by a 75% majority of the shareholders, in which case they could take any protection away from a minority shareholder in the articles by passing a special resolution. It is very difficult to deal with the resolution of any deadlock through the articles. And that's why it's always recommended that they prepare a shareholders agreement. So what are some of the common issues dealt with by a shareholders agreement? There are usually provisions that require certain matters to be approved by all the directors/shareholders before being acted upon, like varying the salary of the directors, that would normally go to the shareholders, entering substantial business contracts, or commencing legal proceedings. There's usually a clause stating what the dividend policy of the company should be. If a shareholder ceased to be a director and/or employee, but remained as a shareholder, they would want to see a certain percentage of the profits declared as dividends. Occasionally, a tag-along right is included, and that is the outgoing shareholder can be required to procure that a third-party purchaser offers to buy the remaining shareholder shares on no less favorable terms as he is getting for his shares. Conversely, the minority may be forced to accept such an offer. There's usually a clause that has the effect of allowing the company to bring an action against, for example, a misbehaving director, which may not have otherwise been possible if that person was the majority shareholder and controlled the board. They normally have some restrictive covenants on the shareholders, which prevents them from competing with the business of the company. Generally, restrictive covenants between shareholders are more easily enforced than those between employer and employee. You could also have an obligation upon shareholders to provide further funds to the company if the company requires it, and to specify the form in which this funding is to be provided. A usual provision when any of the shareholders have given a guarantee for the company's liabilities and obligations is that if those guarantees are called upon to be satisfied, the shareholders will split the cost according to their respective shareholding. It's usual to agree who the auditors and bankers were for the registered office and what the accruing reference date of the company should be, and these matters should not be changed unless unanimous agreement is reached. One of the main issues to consider is what should happen if one shareholder wants to leave the company. Without a clause in the shareholders agreement, a shareholder who leaves may be able to sell his shares to anyone, leaving the remaining shareholder running a company with someone he does know, or the shareholder could refuse to allow the shareholder to sell his shares. It is therefore important to have a set route in terms of how shares are to be sold. So you should decide whether shares must be offered to the remaining shareholders first. And you saw that in some of the cases that we read, where the remaining shareholders have the option to buy the shares first. So most agreements provide for the outgoing shareholder to place a value on the shares, which, failing agreement on the price, would then be referred to an independent expert, and they would determine what's a reasonable value. The next decision would be whether the remaining shareholders would be bound to buy the shares of the outgoing shareholder, and this may not want to or be able to, in which case you need to decide if they would have a choice or not. Problems may arise of funding the purchase if they are bound to buy, and this may not be ideal. If the shareholders refuse to buy the shares, there can always be a provision that the shares are then offered to the company, who must buy them back if there is sufficient cash or bank facility. You may also want to consider whether the shares could be sold to a third party. If there's no particular way of the shareholding, or if there is a stalemate between the shareholders or directors in any respect, then the shareholders agreement can provide for what happens if there is a deadlock. And this could include the above situation where a shareholder is locked in to the company. You also need to consider whether any of the directors are so important to the company that the loss of that person would damage the company's business. In such cases, there is the possibility of the company having some form of insurance against this. For example, key man insurance. Would the cost of this insurance be justified in relation to the benefits? Another extremely important consideration is what should happen if one of the shareholders dies. A number of undesirable situations could arise if no agreement is in place. For example, the surviving shareholder may wish to purchase the shares of the deceased shareholders, but the executors of that person may not wish to sell them. This leaves open the possibility of the widow or the personal representative having an involvement in the running of the business, or the right to appoint themselves as director, which the surviving shareholder may not appreciate. The executors of the deceased shareholder's estate may want to sell the shares to the remaining shareholders, but they may not be able to afford it, and then the shares could be sold elsewhere. So you see how important it is to have a shareholders agreement? It's very important because that it really tells you how to run the company when you can't decide which direction to take it in. A common way to avoid such situations is that the shareholders take out a life insurance policy each and enter a cross-option agreement. The life insurance policy could then be transferred into separate trusts. If one of the shareholders then died, the proceeds of the policy would automatically pass to the surviving shareholder. The cross-option agreement could then state that the surviving shareholder would have to use the proceeds to purchase the shares from the personal representative of the deceased shareholder, who in turn would be bound to sell them. This would benefit all parties because the surviving shareholder would then own the shares and the family of the deceased would receive the money. This would also prevent the situation where the surviving shareholder cannot afford to purchase the shares. Now that's a wonderful idea. The transferability of shares, should these be the absolute discretion of the directors? Or should there be, hold on, let me take that off. Or should there be rights for the shareholders to transfer the family members and into a trust for the benefit of the families? What would be the position on death if you do not have cross-option agreements? You need to consider at what point the various shareholders are looking to exit the company. And yes, when you consider drag along and tag along rights. So what are the common items to be covered in the shareholders agreement? I see what you talk about. I see the slash now. Shareholders agreement / articles of association. You understand why the slash there now, right?
Yes. It's clear now.
Because you have to decide what you're putting in the articles versus what you're going to put in the shareholders agreement, or what you put in the articles, but you want to clarify it more and make sure that the protection is there. You put it in the shareholders agreement. So I don't think I need to go down the list. You didn't read the list, right?
Yeah, this was a really helpful document. I skimmed it. I looked at the list. It's really helpful.
Yeah.
I printed it.
And so this is, I mean, I know of two friends. There were two friends for a while, and they decided to form a company. Articles, memorandum, and guess what?
No shareholders thing.
They couldn't see eye to eye as to how to direct. One wanted to go left and one wanted to go right. And each thought that they were right. And each said, I'm not going this way. The next one said, I'm not going that way. So what happened? There was no shareholders agreement.
Oh my goodness.
The company was at a standstill. You couldn't move. And the board couldn't do anything because the board didn't know where to take the company. One director say, take it to the left. Then the next one will call the next day, say, but I want you all to go to the right. Couldn't work. And it was just so simple to have a shareholders agreement. So now let's go to the chapter on company management. So company management speaks about directors. And just listening to what we just said in the shareholders agreement, that's the document the directors go to after they have looked at the articles of association. They go to the shareholders agreement. So a director is appointed by the shareholders. And their job is to manage the company. And they're supposed to make sure that all the stakeholders are happy. So the act doesn't define what's a director and what's an officer. But we do know in common law that they have a fiduciary duty. And in the act, it speaks to them having a general fiduciary duty. And that's to act in good faith and in the best interest of the company. always subject to the unanimous shareholders agreement and the memo and arts. And don't assume that every company has the same articles. Every company, they would have sat down and made changes to it. So you have to read it in its entirety. So directors are also required to exercise the duty of care, diligence, and skill that a reasonably prudent man would exercise in such a position. And that's whether they are an executive director or a non-executive director. As a fiduciary, directors have a legal duty to act in good faith, not make a profit from their fiduciary position, not to place themselves in position where their duties as directors conflict with their interests, act for their own benefit or the benefit of others without clear, unequivocal consent from the principals of the company on whose behalf they act. And of course, in accordance with the memo and articles. They are supposed to deal and treat shareholders fairly in all classes. So the very first directors are appointed at the incorporation of the company. And that's done by the subscribers. The subsequent appointments are actually carried out in accordance with what's written in the Articles of Association. And that would be followed by what's in the shareholders agreement, like the example I gave you, as to the maximum number that they will appoint. The articles normally specify when and how a board may fill a vacancy for a director, appoint additional directors up to a maximum number, or the articles will speak to how to remove a director. On appointment, a new director needs to sign to signify his consent as a director, and he would execute a director's service agreement, obtain the relevant insurances and indemnities, and of course, we would get a copy of the corporate documents, and the corporate documents would include the memo and arts, the latest financial statements, a copy of all the policies that have been approved by the company. It would give him the organizational chart. He would have to sit with the corporate secretary and review the minutes and the resolutions to get familiar. And then he would also be informed by the corporate secretary of all the statutory or regulatory reporting requirements. So there are usually two types of directors, the executive director and the non-executive director. An executive director works full-time and they're responsible for the daily operation in the company. A non-executive director, he just attends board meetings, and what he does is he gives advice to the board of directors. So he would be the one that would tell them, this is what is happening in the local market. This is what the competitors are doing. And based upon his expertise, he would also bring that to the board and see and give them updates on how their operations are in compliance with whatever his area of expertise is. So in addition to executive directors and non-executive directors, there are also nominee directors. And nominee directors are personal or corporate directors, and they're appointed to act on behalf of the company. They would do this under a corporate management agreement or a nominee director agreement. And shadow directors are persons who, by operation of law and their conduct in relation to management and decision-making, are considered to be directors. And they can also be liable as directors, even though they have not been formally appointed. So under the Winding Up Amendment Act and the IBC Winding Up Amendment Act, they have defined what is a shadow director. And it says any person in association with whose direction or instructions the directors of the company are accustomed to act, but the person is not deemed to be a shadow director by reason only that the directors act on advice given by him in a professional capacity. If a person or entity is considered to be a shadow director, he or it is liable for all legal obligations and liabilities of a director, duly appointed or acting in the traditional sense. The decisions of many English cases have indicated that the test as to whether a person or entity has real influence in corporate affairs of the company to be deemed a shadow director is whether the real influence reference was wielded over the corporate governance of the company by the person or the entity defined as such a director. So the recognition and judicial treatment of shadow directors under common law and Bahamian legislation is to protect the stakeholders of a company from the management of companies by unelected or non-appointed persons. So in the case of Hydrodam Corby Limited, the liquidator of Hydroden alleged that Hydroden's ultimate parent, Eagle Trust, and the directors of Eagle Trust were guilty of wrongful trading on the basis that they were shadow directors or de facto directors of Hydrodan. Further, if Eagle Trust was found to be a shadow director, then all the directors of it would also be shadow directors. The judge, Millett, disagreed that if Eagle Trust was a shadow director, then all of its directors were ipso facto shadow directors. Miller J. clarified that a shadow director does not purport to be a director. He lurks in the shadows, sheltering behind others, who he claims are the only directors of the company, to the exclusion of himself. By contrast, a de facto director purports to be a director without having been validly appointed as such. To establish that a defendant is a shadow director, Miller J. said it is necessary to allege and power who are the directors of the company, whether de facto or de jure. And de jure means validly appointed. That the defendant directed those directors how to act in relation to the company, or that he was one of the persons who did so. That those directors acted in accordance with such directions and that they were accustomed so to act. He stated, what is needed is first, a board of directors claiming and purporting to act as such. And secondly, a pattern of behavior in which the board did not exercise any discretion or judgment of its own, but acted in accordance with the directions of others. You have any questions there on shadow directors?
No, ma'am.
Okay. So I said at the beginning when we started talking about directors that they have a fiduciary duty. And directors normally have that exclusive power to manage the business of the company. The advantage of a board of directors is both concentrated expertise, relative independence from the company's various stakeholders, and the efficiency of centralized decision-making. The disadvantage is that the directors may manage the company in their own interests rather than in the interests of those that they are supposed to serve.
Yes, okay, this is what I wanted to touch on. So let me let you continue. Sorry.
Okay, so how do you deal with this? One, you can give more power to the shareholders. That means that certain decisions are left to the shareholders. Two, you can insert on certain governance arrangements within the board and certain procedures in the decision-making process itself. You could have adequate disclosure to those most affected by the activities of the directors. Third, with the various agency problems arising from centralized decision-making is the one most familiar to attorneys. Legal duties are imposed on directors with set limits within which they must exercise their powers. And these legal duties have been codified in the Companies Act. So three main principles for duty. Duties dealing with the exercise of directors' powers. Duty dealing with skill and competence and negligence. And duty to avoid conflicts of interest. So under the duties dealing with the exercise of directors' powers, that means that they have a duty to act within their powers. They have a duty to promote the success of the company, and they also have a duty to exercise independent judgment. They have one duty dealing with skill and competence and negligence. They have a duty to exercise and prescribing self-interest. And under the three duties dealing with fiduciary loyalty, of course, they have the duty to avoid conflict of interest, duty not to accept benefits from third parties, duty to declare an interest in a proposed or existing transaction or arrangement. Those are the duties, fiduciary duties. So be mindful that a director acts as a fiduciary for the shareholders. And they are also custodians of the assets. And so by law, they have duties, be it legal and statutory, to which they have to comply with. So the question is always asked, to whom are the general duties owed to? Or who are their beneficiaries? Because a director automatically has these fiduciary duties. So that's the question you normally ask yourself, to whom are these general duties owed? And in common law, the duties of directors is owed to the company. Only those who are able to act as or on behalf of the company can enforce the duties. To whom or by whom are the general duties owed? Those who have been properly appointed as directors of the company, even though there are shadow directors. As the spouse in R. Smith and Fawcett, directors must act in the best interest of the company and cannot use their powers to benefit themselves or third parties. The legal test as to whether directors acted in good faith is one in which a director acts into what he believes to be in the best interest of the company, notwithstanding that his decision may in fact also promote his own interests. Directors must also exercise their powers for the purpose for which those powers were given. It is not enough that they simply act in good faith, what they believe to be in the best interest of the company. As a fiduciary, they must exercise their powers prudently and properly and act in good faith, and not just in the best interest of the company, but must also, in the exercise of their powers, corporate, discretionary, and administrative, and otherwise. So as a director, they also have to exercise their powers for a proper purpose, that courts fairly and objectively monitor and assess the propriety of the decisions and actions of company directors. And this is particularly since the notion of what is actually in the best interest of the company is more a subjective test and arguably more suitably determined by the judgment of directors who operate and manage their companies within the parameters of proper and appropriate ethical behavior. Directors must be seen to be exercising their discretionary powers independently and fairly in all matters, particularly those involving their shareholders and in contractual relationship with external and internal parties. In the case of Movitex and Bullfield, it established that directors do not have a duty not to place themselves in a position of conflict in and of itself. They should not place themselves in a position where their personal interests or duties to third parties conflict with their duties to the company for which they are acting as directors without the clear, unequivocal consent of the company. And that's why you see that whenever you're appointed as a director, you actually have to do a conflict of interest check to see whether or not you have any connection to any other company that will conflict with the one that you're being now appointed to as a board of director. And also be mindful that from the financial sector side, there is a limit as to how many boards you can sit on. Directors may be given such consent in the provisions of the Articles of Association of the company or by an ordinary resolution of the company. As a corollary to the principle under which the conflict of interests of directors operates, directors are also prohibited from gaining a profit or obtaining some benefit by using proprietary information, trade secrets, or opportunities that may belong to or derive from the company for which they act as directors. The Companies Act and the IBC Act stipulate the duty of directors to manage the business and affairs of the company, subject, of course, to any limitation or restrictions in the M&As. And of course, looking at the shareholders agreement. So one of the primary duties of directors is to treat different classes of shareholders fairly, particularly where to do so would be in the best interest of the company. So in the case of mutual life insurance and rank, it's stated that it's imperative that the shareholders of the company, as one of the primary stakeholders within the corporate governance regime, be treated fairly in the proper distribution of dividends. Where applicable, the allotment of shares, access to company information, and in corporate decisions made in accordance with the company's M&As. You had a question on directors and their fiduciary duty?
No, no, not really, no, ma'am.
Okay.
I just thought about the disclosure of the conflicts of interest. So it is the director's duty to disclose any conflict. So let's say you're working at a firm and you don't feel that the company's best interests are, the fiduciary duty is not being upheld. So like who would speak to that? Who would, I guess, call it out? Whose job is it to say, look, this, like what happens then? Like,
okay, when you say, okay, hold on, stop. When you say the fiduciary duty is not being done, what do you mean?
Okay, so they have it's all about the relationship and them having more like an obligation to act in the best interest of the company, the directors, that is, right?
Yes. Uh-huh.
So if that is not being, and I heard somewhere that it says it's subjective, but let's just say that, it's not being, the company is not being run, in accordance or the shareholders' best interest is not being considered. It's, and I see a lot of Bahamian companies operate this way, like they're just sitting there serving this post.
Mm-hmm.
If one feels that it's not being operated properly, because
Who's the another?
Yeah, that's what I'm trying to get at. Like, gosh, I don't know what I'm trying to say.
No, I get where you had it, but I'm trying to see who is the person who feels that the director is not acting in the best interest.
Okay. Let's just say it's a random employee, not even a senior employee, but a junior employee makes mention of this to her superior, to her supervisor.
The only thing, that's not a whistleblowing matter.
Oh, it's not. Okay.
No, it's not a whistleblowing matter. Remember now, a director's duty is to the company. So when the board reports to the shareholders, the shareholders should be able to see
okay,
whether or not the company is being run the way they wish for it to be run.
Got it.
And don't forget, they also have audited financial statements. So when the auditors also give them a peep as to how the company is being run.
Mhm. Okay.
So if you're looking at an employee saying that the directors are not acting in the best interest of the company, that should be reflected in the minutes. So that issue then is directed towards the chairman of the board. The chairman of the board is the one that directs how the board operates. Because the shareholders speak to the chairman. So if you could have given a good example as to what you or what you would determine as the director not acting in the best interest of the company, then that probably could narrow it down a little bit more to see what box it fits into.
Yeah. I can't, no, I don't have any specifics, no. Yeah, and that's why it is subjective, because one person may think that way, but it may not necessarily be the case.
But I mean, there are instances where you can have a director on the board, right?
Right.
But tell you this, if you like how you're studying company law now, no company law. If you didn't know company law, you probably wouldn't be able to identify it. But let's have a director on the board. And that director has a certain expertise. Everybody comes to bring their expertise to the board. So let's say this person has an expertise in what? Let's say what? Climate change, since that's always the talk. Yeah. So let's say he has some expertise in climate change, some geological something degree. And this is a company that does oil drilling or does, I don't know, something to do, they're building something, a hotel or marina on some key. And he's sitting at the board, right? And on the table is the expansion of a boat slip. Okay? And so everybody has made their contribution. Some people spoke about the risk. Some talk about the cost. Others said would say these are the requirements that we need to get our approvals from the government. But this director sitting there with that knowledge knows that if that terminal is built or that slip is built, that even though they got an independent report saying that the damages will be minimal, he knows based on other research that that minimal disruption will only be for the first 3 to 5 years. But after traffic gets heavier, it will impact it. And he says nothing. That director then needs to be exposed. If it's a regulated entity, that can be exposed to the regulator anonymously.
Would that exempt the company from repercussions and have it just fall on the director, or how would that, or do they share consequence?
Oh, it'll be the whole board.
Mm.
The whole board.
Sorry. Good afternoon, by the way.
Good afternoon. It'll be the whole board. Now, let's say if it's a private company, it depends on the connection between that director and the shareholders. Because if that director is very close to the shareholder, they won't entertain whatever comments you make. And again, it can be sent independently, anonymously to the shareholders. Because they will look into it. Because their investment is at stake. What else are you thinking? Because that can't go through the whistleblowing process. But you always have to think of whether or not they're acting in the best interest of the company. So even though the directors are responsible for the day-to-day management of the company, their powers are not unlimited. They can only go as far as what's in the Articles of Association, and that's capped again by the Shareholders Agreement. Whatever their authority is, that is restricted by what's in the Act itself and the company and the Articles of Association. They can't delegate their power. But whenever the board sits, they must act collectively as a board to bind the company. And another thing, Shirella, you can see is if you have access to the board minutes, and because now you're doing company law, sometimes you can look at the trend of the voting. You can read the minutes and you can see, you can actually tell where board members would have colluded between themselves to come to a decision, which may not be in the best interest of the company. Or you could have it where you have, remember when I was talking about having 2 shareholders or 3 shareholders, and there is a dispute, one is going to the left and one is going to the right. You can also tell when directors get together and they're making a decision and which direction they're headed in, you know which shareholder they're siding with. So whenever there's a breach of any of the duties, that breach goes to the directors. But as a general rule, a director cannot be liable for the fraudulent, criminal, or bad faith acts of his co-directors unless he has taken part in that act, or he doesn't have any knowledge or suspicion of those acts. But if a director is involved, then he is jointly and severally liable for his co-directors, and he may be liable to make good the whole of the loss with his co-directors. And the only way that doesn't happen is if it was done for the sole benefit of just one director. Directors may be liable to account for any secret profits that they may have made. And I know you hear a lot of this happens right here. Secret profits means cut underneath the table, 5%. So in those cases, the company would be entitled to void any contract it may have made with them. Additionally, any company property that the director may have taken or transferred to a third party may be recovered by the company, except, of course, when the property was given in good faith and for value. And that means without notice. So under common law, in the case of Brantford and Brantford, a company may, by ordinary resolution, waive a breach of duty by a director. And that depends on the gravity of the matter. A court has the power to grant relief to a director who has acted honestly and reasonably, and who, in view of the facts of the case, ought to, in the circumstances, be exonerated. Now, directors also have indemnification. And many directors are seeking protection from liability and risk exposure from their companies and its insurers within the legal limitations imposed by statutory and common law so that they can have some protection. So under Section 118 of the Companies Act, it allows a director and his legal representatives to be indemnified by the company against all costs, charges, and expenses which may reasonably be incurred by him in respect of any civil, criminal, or administrative action or proceedings to which he may be made a party to by reason of having been a director of the company. Under the IBC Act, it allows a director also the same protection. The statutory right to indemnification is only permissible to directors and their legal representatives of both the CAC and the IBC, provided that such directors acted honestly and in good faith and in the best interest of the company, and where they had reasonable grounds for believing that their conduct was lawful in the case of a criminal or administrative action or proceedings. So directors and officers liability insurance. Since directors and officers may be personally liable for any party that may have an interest in the affairs of the company for damages, legal costs, and expenses in relation to a breach of director's duty, many of them seek protection of directors and officers liability insurance. And directors and officers insurance are designed to protect a director or an officer against claims that may be made by a company, the shareholders, or the creditors. So under the CAC, a company may purchase and maintain insurance for the benefit of a director against liability incurred by him in his capacity as a director of the company. And then under the IBC Act, it allows a company incorporated to purchase and maintain insurance for a director, for the registered agent, the officer, or the liquidator against liability incurred by such person acting either as a director, a registered agent, officer, or a liquidator. So notwithstanding the provisions and protections of directors and officers, liability insurance, it is important that executive and non-executive directors ensure that they are properly and sufficiently covered when agreeing to accept and act in that capacity. So that's the first thing when you're appointed as a director, you have to ask, the first thing you ask, can I see the insurance coverage? Because you want to make sure that the coverage is adequate for what you're about to do. Newly appointed directors would be advised to seek an independent advice and review of the indemnification and insurance coverage offered by their companies and the extent of their personal protection against claims, actions, and proceedings. Since directors and officers cannot rely for protection on the separate legal personality of their companies, as enunciated in Solomon versus Solomon, and protection is provided for the company's assets in respect of reimbursement of directors and officers, indemnification and insurance coverage should be a primary consideration in the exhaustive list of requirements of a company before accepting to act as director. the increasing number of claims of shareholder and creditor litigants, the rising cost of litigation, and the personal assets of directors that may be at risk should encourage companies, directors, and their relevant advisors to work collaboratively with audit and corporate governance committees to ensure not only compliance with internal, legal, and regulatory requirements, but also sufficiently comprehensive legal and financial protection, particularly for directors and officers who maintain the gatekeeping role and risk and responsibility of the company. Generally, statutory duties do not apply to officers, such as managers, because they are not directors. Note that when applying the law relating to directors' duties, the courts do not distinguish between the actions of a director as director and the actions as manager. Whether director is an executive, those duties will apply to both aspects of the director's activities. Therefore, some actions by senior managers of the company, provided they are also directors, will be subject to the controls of general statutes. So in addition to company directors, officers carry out the operational and daily mandate and activities of the company. They oversee the supervision of critical corporate duties and responsibility. Such officers are normally answerable to the board of directors of a company. Under Section 2 of the Company Act as amended, an officer is deemed as the chairman or deputy chairman of the board, the president or vice president, managing director, general manager, controller, secretary, and any individual who performs for the body corporate function. Under the CAC, the directors of the company may designate the officers of the company, appoint as officers persons of full capacity, specify their duties, and delegate to them powers to manage the business and affairs of the company, except powers to do anything except the powers designated in Section 103. The director of a private company may be appointed to any office of the company, and a director of a public company may be appointed to any office of the company. 2 or more offices of the company may be held by the same person. And then under the IBC Act, it states that the directors of a company may, by resolution of directors, appoint any person, including a person who is a director, to be an officer or agent of the company. And subject to any limitation in the M&As or in any unanimous shareholder agreement, each officer or agent has such powers and authority of the directors, except any power of authority as the directors may have to appoint officers and agents or determine their emoluments. The directors may remove an officer and appoint or agent appointed under subsection 1 and may revoke or vary a power to him under subsection 2. And of course, the Act speaks to having a standard of care. It says every director, officer, agent, and liquidator of a company in performing his function shall act honestly and in good faith with a view to the best interest of the company and exercise the care, skill that a reasonably prudent person would exercise in comparable circumstances. So the fiduciary role, duties, and responsibilities of directors and officers in the management of companies are significant and pervasive. The challenges of good corporate governance, increasing shareholders' rights, improper action by directors, and pervasive legal liabilities of risk exposure to directors for the performance and propriety of companies make it more challenging for directors to clearly define their roles in the ever-changing environment of modern-day commerce. So let me ask you all a question. After all of that, can you list for me 10 important duties of a company director?
To act in good faith and to promote the success of the company. They should act in the best interest of the company. They should seek to avoid any conflicts of interest. They must manage the company. They must not treat shareholders differently. That's all I got.
Okay, Christine, I know you just joined. So what else? You know some more, Sharella. Come on, come on.
She knows some more, I'm sure.
Okay, I feel like I'm repeat. Okay, so I don't want to duplicate. Okay, so they shouldn't treat shareholders differently. They should avoid conflicts of interest. They should they have the fiduciary duty. They have a fiduciary duty. They have the duty to act with skill, care, and diligence. They must exercise independent judgment. I said avoid conflicts of interest. They must. Okay, sorry. Because it's so important for me. They must act in good faith and must ensure that the company is successful. And they must act in accordance with the company's bylaws. 1, 2, 3, 4, 5, 6, 7, 8.
That there.
They must not accept any like profits, underhand table profits from a third party.
Come on.
What about competition? Something about competition, like
Conflict of interest, is that?
She did
Oh, you
conflict.
already say that.
Yeah. What about disclosure? You remember? If they have an interest.
Right. Yeah, that's what I was meaning. Like the that's when they would disclose to make sure that they're not trading any secrets and stuff, like trade secrets, confidentiality, not confidentiality, like competition, to ensure that if they do resign, they're not going, like the company would still benefit or wouldn't be in a awkward state because they're going over to a competitor. Even though I don't believe that stands. I think that even if a director was to resign, they will still use what they know to benefit the competition or whatever new company there. So why
it's hard not to.
What you saying, Christina?
I think it's hard not to. When you know something, you know it. It's kind of hard not to to pretend like you don't know something. And
right, but that's the difference. But there are some people that intentionally like they just, I can't explain it. I can't explain it. It's one thing that you're knowing, but it's something else when you're taking the old company's documentation and data to benefit the other company. Like you're literally
different. Yeah. That's almost like a Sprint versus Verizon situation with the mascot guy thing. So I think she said all.
You did?
I think she said all.
No.
The only one that I don't know if it relates to something she said is if a director knows about something that could potentially harm the business and don't disclose it. Yeah, that's one of their responsibility, to disclose anything that may be potentially harmful to the business, whether present or future or whatever. She might have said something like that though.
And what about complying with legislation? Regulations and legislation. They have a duty to do that too.
Right. Yeah.
And they also have a duty to ensure that the company maintains its filing and reporting obligations.
That's the directors?
Yes, they are.
Or the secretary?
No, the directors.
Wow.
The secretary does the work.
Right.
Directors have that responsibility.
Like oversight almost.
Yeah, but they're
large companies that have like a lot of directors, that like all of the individual directors collectively have that responsibility.
Yeah. Yes.
Okay.
They do. The same way with requirements for the law. So let's just say in your role, in your role, you say, okay, I make sure we file this, I make sure we file that, and that. Not knowing that 2 other pieces of legislation came out, or there was an old legislation that no one probably never checked for. And when you came to the job, you notice you never even bothered to notice that this one was not being followed. Let's just say that. So here you are now, someone called, either from government, regulator, someone called and say, we notice that you have not filed a statement or declaration for the last 3 years relevant to so section so and so of the act. This you now. As a part of your job, you should have known and filed. Because if that refers to a fine being paid, where does that go? The directors have to explain.
Ooh. And so is that why then a lot of companies would opt to have a registered office?
Now,
Someone that can
regis-
keep them up to date. Well, I guess even like a law firm on the whole.
no, don't mix it
No?
up now. Registered office only means that's where, when you have a matter to be served, that's where that document goes. The registered agent is the person that prepares all of those things on behalf of the company. Depends on the purpose for which the company was incorporated. So normally for a CAC company, if it's not one that's operating in the Bahamas, let's say if it's foreign, they would have a company, an FCSP, that is their registered office and registered agent. In some instances, the FCSP prepares all of these things that we talk about on behalf of the company. But in some instances, even though the FCSP is the registered office and registered agent, the board and the secretary of that board, wherever they are in the world, they would prepare the resolutions and also forward the minutes of the meeting. And the only thing the registered agent would do would be to update the register of members, officers, and directors. Transfer shares if necessary. So there's only just carry out the actions based on the minutes.
Oh, so okay, you mean like in terms of preparing the financial statements annual ones based on the minutes and incumbency stuff?
Yeah.
Okay.
Certificate of incumbency or requesting a certificate of good standing, ensuring if it's a CAC, ensuring the register of members and officers are filed with the registrar general. For an IBC, making sure the accounting declaration was submitted at the time the company was incorporated. That's what the registered agent does.
Okay.
Why you breathe out?
No, I just was digesting what you said.
Yeah, so whenever a person is appointed as a director, the first thing they need to ask themselves is, what is my role as a director? And the director is in charge of the management of the company's business. They make the strategic decisions and they make the operational decisions. And they're also responsible for ensuring that the company meets its statutory obligations. So let's just say someone decides that they want to form a company, 4 people. And they say, this company, they're going to be selling vegetables, since they say we're doing backyard farming. So let's just say they're going to incorporate a company, and that company going to be selling plants, vegetables and fruit trees and whatever from all around the world. So they've expanded from just the native. And they met you one day at a nursery while they were in the process. And you started to tell them how you know a lot about plants and you've been doing this for a while. You've been to a couple of the government sessions on backyard farming and this and that and that. And they ask you for your business card. They may look you up if they, get ahead with forming this company. So let's just say a couple months later, you get a phone call and they say, we have formed the company and we would like for you to sit on our board. And if you agree, we would also like for you to be the chairman of the board. And you can go and find your other directors. We may know 1 or 2, but we'll let you know. So now you're the chairman of the board. You have the memo and the arts. What do you do next? Because you're a director and you're the chairman. What do you do next? Would you not, you have to sit down with the shareholders and see what exactly is their vision for this company? Because you have the responsibility to manage this. And you have to take that idea that's in their head and develop a strategy. And you have to find people to put on the board who are going to help you to implement that strategy. And you're also going to have to put someone on that board who can help you to make sure that the company operates to its fullest capacity. So who would you select to put on this board? Who would you recommend to the company, I mean to the shareholders as prospective directors?
I'm trying to think if there's a straight answer or not.
What you mean?
Because you said that the chairman is responsible for selecting the directors, and so is it the question is who should the chairman, if I'm the chairman, decide to bring onto the board?
Yes. Even though the shareholder may say, I may have one or two suggestions. They may decide that they want you to look for one or two directors in addition to who they're putting on.
I want the people who went to BAIC training who know what they're doing.
Of course. But you don't want everybody with the same training.
You want people with diverse sets of training, like in terms of
Yeah.
marketing and finance and stuff like
Yeah.
that.
Yes.
Oh, okay. So that's
Yes.
the answer.
Yes. You gotta have a diverse board. Otherwise, you're going to be stuck. And you also want someone who knows about new technology.
Right. So I have a question because I've never thought of it that way at all. So these are just like directors are essentially employees to the company, but they have a deeper relationship with the company in terms of, law stuff.
Yeah, but they're not employees.
What? The directors aren't employees,
No.
but they're gonna operate as employees for the best interest of the company.
No, they don't operate as employees. They are, a director has a fiduciary duty. Employees don't have a fiduciary duty.
So do directors get like salary or stipend?
No, they get a stipend every quarter.
But they're not, but they can't, what do I want to ask? They can't share in profits, that's for sure,
Unless they're a shareholder.
unless they're a shareholder.
Mm-hmm.
So they get a stipend every quarter.
Right. And that stipend depends on the company and the profitability of the company. And remember, the unanimous agreement can actually state the limit that a director can be paid.
Wow. Yeah, that's true.
Right.
So then who pays directors' national insurance?
That doesn't come out of that.
I know, because that's not a salary. So that
They
wouldn't.
have, if they do not have a permanent job, then they'll have to pay as self-employed people.
Huh?
Yeah.
Voluntary insured?
Yes. Don't forget now, as a director, they would have insurance from the company.
Right. And they would have certain other benefits then.
No, what other benefits that could be?
I don't know. They wouldn't give them like health insurance.
No, none of that.
Is it because they don't have to?
No, the director, you just come to board meetings.
Okay. So, but
And
they don't deal in the day to day then
no,
of running of the company. They would just sit and meet and plan and strategize.
they just strategize and then they give it to the CEO.
Oh. Okay.
That's what they do.
And the CEO would then hire people that's in charge of certain things
Yes.
in the company that runs it every day, day to day.
Yeah. And the CEO reports to the chairman of the board.
So directors could essentially then, if they want to work either for themselves in their own individual companies or with other businesses or with other companies,
Yes.
their only purpose is to come together and to strategize and stuff.
Read the reports and see if the company is going in the right direction and if it's in compliance with the laws and the regulation.
And their job also is to report to shareholders what's going on.
Yes.
Okay.
So some
Okay.
shareholders may call the chairman in mid-year and say, can I see the accounts for the 30th of June? Because they want to going. Based on unanimous shareholders agreement, they may say dividends are to be paid every 2 years, every 3 years. So they want to see how the company is going. Do we expect a loss? Looking at this matter here, it says here for the last 3 meetings that we really have an issue with reputational risk. How would that impact the bottom line? What are we doing about it? What is the risk manager doing? What areas is it?
Okay.
That's the problem. And then it trickles down like that. So sometimes when you sitting at the bottom, see the pressure coming, you be saying, what does even ain't important? Why are they worrying about this? Because it's deeper than that.
Right. Okay. It's like, okay, I get that. But there are some cases though where the CEO is also the managing director and is also the shareholder.
Yes.
How then, and I just probably don't have an analytical response to it, could they separate those roles? Because they're separate.
That's a big question. And I know we have some of them here that are carrying 3 and 4 and 5 hats.
Yeah.
And you normally have that in the startup because they don't trust anybody else.
Say again, because
yes. And don't trust, and at the same time, in their view, and it may be right, it may be wrong, there's no one here with that knowledge.
Right.
To set it up. Dangerous. If you set it up, you cannot separate the roles.
I have another question. So I don't think, from my understanding, directors can't be changed like a quick turnaround. Employee could be changed.
Why?
They can be?
Yes. The shareholders can call a meeting.
And remove them immediately and place somebody else in place?
Unless there's some restriction in the articles.
Okay. And that this report can go into the Register General's office at any time?
You mean your amendment?
Right, to update the Register of Directors.
You normally do it once a year, but you could do it at any time.
Yeah, that's why I was asking, because I know it's normally done once a year, but it can't be done throughout the year. Oh, wow. Okay. Wow. Okay then.
So you can sit on about 4 boards, depends on the size of the company. And for each board, you may be paid $3,000, $4,000, $5,000
per quarter or per annum?
Per quarter.
As a registered office that's operating as a FCSP, you can also offer the service of sitting on the boards for companies that you incorporate.
Yes.
And they would be responsible for paying you whatever amount.
It won't be that much. You'll be paid a director fee.
Right,
That's
right.
the agreement.
Right.
You can get the services for a director. You can get the services for a secretary.
Right.
What again? I ain't very.
No, because I was just thinking about, that's me processing.
I know. So what you'll see some FCSP do is they incorporate companies to act as directors.
Wait, what? You mean as a okay. You mean, okay, wait,
It depends on the structure of what you're doing.
right. So you could, but that can happen with a CAC company. You can have a company that acts as a director on a CAC company, or does it have to be IBC? And I'm sorry if this is an ignorant question, because I didn't
No.
fully read the rest of the stuff.
On an IBC.
On an
But not-
IBC, not CAC.
No,
Okay.
it depends on the structure
Okay.
and what they achieve.
Okay.
If when we do company law 2, you'll see that we have a lot of products, and the products that you choose depends on the structure and what you're trying to achieve.
Right. Okay. Mm,
So remember the last hack they had with the Registrar General, and they
Yeah.
thought that they got a lot of information and they were not able to get what they were looking for. First, they thought that they would have been able to identify who were the UBAs of all of these companies. They couldn't find that. Then they know who were the directors of the companies. All the directors were Bahamians.
mm,
All those that had names of individuals were those that are traded on the stock exchange.
okay.
It's nothing illegal. It's
Mhm.
allowed us.
So with the security commissions, I guess especially for if you just incorporate in CACs, you could just register as an agent under the security commission? Or is it best to do both?
What you mean register as an agent?
Apply under the security commissions to be a registered agent
No,
and
no,
office
you have to apply to be an FCSP.
with the security commissions.
Uh-huh.
Or they don't distinguish.
No, an FCSP is the license that you get. So
Uh-huh.
when you apply to be an FCSP, then you say what services you're going to provide.
Okay.
And then you could say, I'm going to be offering registered office services, registered agent services, the different services that fall under an FCSP.
Okay. But the requirements won't be as stringent if you're doing just corporate services, not financial services.
Yes, correct.
Hmm.
Because normally if you're an FCSP, you really will not be doing financial services. You really just doing registered office and registered agents. If you add into that now doing financial services, I guess if you have an accountant in there,
Mm-hmm.
can. But it's going to be more reporting obligations on you.
Yeah. Yeah. But you can, if you want to, just apply as a agent, or it would have to be both registered office and agent, or FCSP offering the services of agent and office.
No, you could do either or, because some people will have their registered office maybe at a law firm.
Okay. Okay.
It's a growing business.
Mm-hmm.
So most definitely, there's a question on the final exam on directors and their management of a company. I'm sad to see that the rest didn't come because, like I say, this is an examinable area. But they can listen to the recording and go from there. Any more questions? Would you like to have a homework question?
No homework, no question.
No, please.
Yes,
Please.
We're still trying to do the midterm, remember?
I know that.
Not
But I'm-
only the midterm, I still trying to catch up.
Oh, well.
I'm only
Okay,
asked-
okay, give us a question, but just don't pressure us next Saturday. Like, you
Yeah.
know, like if we do it, but if we don't, it's okay.
Especially if it's just about directors. I think I could do that.
Okay, I'm gonna do a very, very short one. I can give it to you right now. If anybody
Okay.
short, this is short.
Okay.
Okay. Let me give a name. Barry was appointed managing director of,
You'll email it, right, Ms. Archer?
yeah, but I give
Oh,
it to you.
Okay, no problem.
Okay. Barry was appointed managing director of Guava Limited. I think about my guava tree. With a service contract for a term of 4 years. A group of shareholders is dissatisfied. Group of shareholders is dissatisfied with Barry's conduct of the company's affairs and wish to remove him from office. Advise the shareholders.
Okay, that sounds good. That's a decent question.
Yeah, I told you it wasn't hard. On the finals, it won't be that easy, but anyhow.
Oh my gosh. Oh Lord.
You'll have some time to think. So that wasn't hard. If not, I could have thought of a harder one, but that'll do. Yeah. All right. So I leave you all to catch up. No class next week, remember?
Awesome. No, I didn't remember.
Okay, no class next week.
Okay.
Okay. All right.
Thank you.
Thank you.
So
Bye,
enjoy the day.
Bye.
Bye.